The Plano County Combined Court. This is Kristen.
Hello, Kristen. I'm calling in to Mr. Herringer's court.
I'm sorry, whose court? Judge Herringer's?
Yes.
Okay. What was your name?
Little Deer.
I'm sorry, what was that?
Little Deer.
Little Deer. And do you have a case number?
I don't.
Okay.
It's not in front of me. He's expecting my call.
Okay. All right, give me 1 second.
It's kind of a strange disclosure, but I might as well go ahead and put it out there. Last week, the court received some sort of packet addressed to me. It was a probably 10, 12 different documents. And the packet was pretty incomprehensible, but I've waded through some of it just to try and figure out what was going on with it. It looks like the packet mentions it's really in a number of different places. It says things to the effect that she is a vessel lost at sea and other things along those lines. It did not mention this case. It was not filed in a case, but it was directed to me. And it mentioned this story. I don't know whether or not it came from her or it came from somebody on her behalf, but it has her name in it. It's addressed to me, and I didn't look at it, even though it's not filed on a case. I thought I should at least bring it up and let everybody know about it. So, I couldn't even figure out what the release was that, if any, was being asked for in the document. So, let me start with Ms. Padilla. Ms. Padilla, what's your position regarding the suspension of the visitation?
I'm asking that the court suspend visitation between Victoria Swilley and her mother, Ms. Swilley. I think it's in the child's best interest. I'm very concerned about Victoria's mental health, not only because of Ms. Swilley's deteriorating mental health, but also the equine therapy visit, I think, was very upsetting to the child. I did address this with Victoria. I met with her on the 22nd of February, which was this Monday, and she indicates that at this time she's okay with not having visits. She is requesting that she has phone calls with her mom every 2 weeks, and that her mom be allowed to write her letters that go through the department. I am concerned about both of those requests from the child. I received a 4-page document that I think is similar to what the court received, that I was unable to really understand what it was saying, other than something along the lines that no one could use Ezekiel Swilley, Victoria Swilley, or Catherine Swilley's names because they've been copyrighted. But the rest of the document was pretty difficult to understand. And when I met with Victoria, I explained to her that I was concerned about Ms. Swilley no longer engaging in therapy, about her no longer taking some medication, and that she had had some pretty concerning things to the department. Victoria wanted to know what those things were, and I gave her a little bit of an idea of what the letter said. My understanding that Zeke may have seen the letter, and it was very upsetting to him. Upon recommendation from Victoria's therapist, both a psychiatrist as well as her ongoing mental health professionals, they recommended that I not share that letter with her. But so I'm concerned about Ms. Swilley's ability to write future letters, but if she wanted to try and propose it to go to the department, and if the department follows it, it's appropriate enough to be passed on to Victoria. But I am requesting that no additional visits occur at this time. I also think it's important for the court to know that Victoria was moved from her foster home after her first foster home yesterday. I'm very concerned about her mental health, and I think exposure to Ms. Swilley is going to make that worse. So I'm requesting that the department's motion be granted.
Mr. Shaner, do you wish to be heard on behalf of Ezekiel?
Yes, Your Honor. Yeah, excuse me because I'm fighting a cold and my voice may kick in and out here. I've spoken with Zeke about it. I agree with the motion by the department. Zeke does not want visits. He's very concerned about the deteriorating mental state of Catherine. He did see the 4-page document. It was upsetting to him. she believes that her mental state is getting worse all the time, as exhibited by this document. Quite frankly, he's afraid to be around her right now. So, for the other reasons, as stated by Ms. Padilla, we would join in the motion and ask that there not be any visits right now.
Mr. Eli, I realize that you're very new to this case, and I'm not sure if you even had contact with your client yet, but let me hear from you.
Your Honor, I spoke with the guardian yesterday, and she indicated that she would like the kids returned to her, and she doesn't believe there's an issue that needs to be addressed.
All right. Well, based upon the representations contained within the motion and the statements, particularly the statements of the two guardian ad litem, the children, I am going to temporarily suspend visitation on the motion. Mr. Ely, I would assume that you would like an evidentiary hearing regarding this.
Yes, Your Honor. The one issue in talking with the guardian is she said she would be here today, but she also said that she believed it was illegal for her to come to the building. Maybe you could inform her that she could show up for that hearing.
So I'm going to go and set the hearing, and we can talk about it there. Yeah. How much time do we have? An hour? The next setting I have is the 10th. Some chance I could do it earlier in the week if my jury trial that I have scheduled goes away, but I won't know that tomorrow. So I'm thinking about just leaving it on the 10th, which is our next appearance in this case anyway. I was just going to advise the court and parties that we are going to be requesting a permanent hearing in this matter. Obviously, knowing that we have required proceedings on that, so we'd like to schedule that too. Schedule the permanency hearing. How far out do you want the permanency hearing? We're asking for the same date. We have a review that day, then we have now this, and I've got an hour allocated for the case. It seems like an inadequate amount of time to deal with visitation and also permanency hearing. Do we have time in that day, or the next available date? Well, actually, I guess we could move this case up to maybe up to 9:30. I don't think JV 49 will take that long. So why don't we expand this case to 9? We'll start this case at 9:30 instead of 9:30 to 11. On the 10th, make it an hour and a half, and then we can also set it for permanency hearing. All right, so essentially the way that I view this is that the emergency request, I'm willing to grant that based upon the representations of counsel and the guardian ad litem. I do think that whether or not the ongoing best interest of the children to continue to suspend visitation, I think the court needs to take some sort of evidence, so that's what we'll plan on doing on the 10th, so I can have actual evidence presented and also have the story of an opportunity to participate in that. Ms. Willie, we set this you were originally set for the 10th, but I basically set it for more time and for hearing on the motion for visitation. You understand that?
I did hear, yes.
Okay. Are you going to be here on that day?
Well, I have things here to address with you this morning.
Okay, what would you like to address with me?
Or this afternoon. My concern about the legal name not being, it's illegal to use that name. It's copyrighted material. I understand that it sounds as though maybe it's not understood. So maybe you can clarify for me about the use of the legal name.
Okay. I've been practicing law for 20 years. I've been a judge for 3 years now, almost. I have never heard of any such prohibition regarding the use of a person's legal name or the copywriting of a person's legal name. It's contrary to basically all principles that I'm aware of in the law regarding how the law functions and the need to be able to identify people so that we know who we're talking about and render judgments that are specific to people. So I don't think that there's anything illegal or improper about using a person's name.
Well, it certainly has never felt unnatural or improper. It was the given name at birth by my parents. But after doing very careful searching on this, it has come to my attention. This is Crown copyrighted material. Those legal names are copyrighted, and I don't have permission to use those.
And who is going to punish you if you violate that?
Well, it does get, it gets to be, the consequences, I believe, can be very severe.
But who's going to impose those consequences?
Well, it's kind of a universal law. I guess on a spiritual level, there are consequences on every level. I'm concerned. If you can give me written permission to use those legal names, then that would give me some confidence. Can you do that?
I'm certainly more than glad to put something in an order that says that the court is aware of no prohibition against the use of the legal names of either you or the children.
Well, if you can put something in writing for me that says we do have permission to use those legal names, that will certainly put me in a position where I can now speak with the attorney.
Well, I'll put something in writing that will hopefully facilitate this. I don't think it's necessary for me to give you permission because I don't think you're prohibited. And so
that's okay. I do. I've seen way too much, in trying to understand the legal definitions of things. This just came with understanding. So I apologize if people there are not clear, and if they mistake this for some kind of a mental breakdown. It is not a mental breakdown. I don't want to break the law.
Well, I'll take you at your word that you're not having a mental breakdown, and assume that you're thinking rationally. And what I will tell you is that if you are a rational person and I'd ask you to listen carefully to me. I am firmly convinced that what you presently believe regarding the use of these names is wrong. Okay? And that you have identified a problem that doesn't really exist, and that it's not helping you in terms of your goal of getting the children back. It is actually complicating things and making things worse for you as opposed to actually helping you. And I would strongly encourage you to focus on your efforts on things that will actually maybe bring you to reunification with the children as opposed to this, which is seems very misguided to me and very mistaken and unnecessary. I will put something in an order saying, again, that there is no prohibition against you using your legal name or the legal name of the children, and that is proper and lawful, and that hopefully that will be sufficient for you to have some assurances regarding the fact that you're not violating the law. But I've never heard of anybody ever having any sort of...
It's very strange sounding. Okay, I understand that. I thought that you might be more intelligible on the subject than anyone else.
That's